Good afternoon and a very warm welcome, ladies and gentlemen. Thank you for joining the Gauteng Attorneys Association as we present a virtual Q&A with the Honourable Judge Norman Davis surrounding the Mediation Directive. As a starting point, a very warm welcome and thank you to Judge Davies for joining us, and a thank you to the executive of our Gauteng Attorney Association member associations, being the Johannesburg Attorneys Association, the Pretoria Attorneys Association, the West Rand Attorneys Association, and the Soweto Legal Fraternity, the exco for each of these respective associations for joining us. I'd also like to thank members of our Gauteng Attorneys Association associations who have joined us, as well as members of the Black Lawyers Association, NADEL, and many other associations across the province, as well as across South Africa, for joining us for what will be an informative afternoon. I'm just seeing in the comments already, we've got someone who cannot hear. I just want to confirm, am I audible to everyone on the call?
Yes, you are.
Thank you very much. So a very warm welcome to everyone who has joined us this afternoon. And the backdrop of the session this afternoon comes on the back of what we have seen just last week, and that is a revised edition of the mediation protocol that was circulated as well. That just provides us with a little bit more guidance on the mediation directive in the Gauteng division of the High Court. So I'm not going to take a lot of your time, as I'm sure you are not here to listen to me. I want to just introduce myself first. My name is Azhar Aziz-Ismail. I am the chairperson of the Johannesburg Attorneys Association and an executive of the Gauteng Attorneys Association, and I'll be your chair for the session this afternoon. I'm also joined by other EXCO members of the Gauteng Attorneys Association who are on this call and will assist with different parts of the call. From a housekeeping point of view, I'm going to request that we all keep our cameras turned off and our mics muted. When you do have a question, please raise your virtual hand on the Zoom platform and you will be able to be recognized. And once you are recognized, you can then turn on your camera if possible, as well as unmute yourself to ask a question. If you are unable to unmute yourself and are having difficulties, you would have the possibility to type the question into the chat. However, we would prefer if we keep this as conversational as possible. I also would like to remind everyone that this session is being recorded and will be available on the Gauteng Attorneys Association's YouTube channel. So it goes without saying that this session is a Q&A informative session, and we need to ensure that as sometimes we may get a little bit heated, it is important in our profession to remain professional and collegial. With that, I'm going to now call upon the current chair of the Gauteng Attorneys Association. Following our last AGM, we have not yet appointed the new portfolios of the Gauteng Attorneys Association. So I introduce to you again the chair of the Gauteng Attorneys Association, who is also a treasurer at the Johannesburg Attorneys Association, Yusuf Wadi, who will introduce the Honourable Judge this afternoon.
Thank you kindly, Chairperson. And hello, colleagues, and thank you for joining us. It's my privilege to introduce Judge Davies, who I'm sure everyone is fully aware of his stature within the judiciary. Judge Davies' journey through the legal fraternity is one of dedication.
Apologies, Chair. you were muted when we muted the new guest who came in, so you may have to just take one step back with your introduction, please.
Thank you. Apologies for that. Am I back online?
You're back on.
All right. Thank you, everyone, for joining. And on behalf of the Gauteng Attorneys Association, we welcome you and we welcome Judge Davies for giving us the privilege of his time. As an introduction, Judge Davies' journey through the legal fraternity is one of dedication, scholarship, and unwavering commitment to justice. He holds a BCom Law and an LLB from the University of Pretoria and an LLM from the University of South Africa, which he completed in 1991. His early academic focus on property and expropriation law foreshadowed the thoughtful, balanced approach he would later bring to complex questions of rights and governance. After beginning his career as an attorney, Judge Davis was admitted as an advocate in 1990 and quickly built a respected practice at the Pretoria Bar, specializing in administrative, commercial, and property law. His professionalism and integrity earned him recognition from his peers, and in 2006 he was appointed senior counsel. Beyond his legal practice, he contributed significantly to the leadership of the Pretoria Society of Advocates, serving first as the deputy chairperson and later as chairperson. In those roles, he was known for his mentorship, fairness, and firm belief in maintaining the independence and dignity of the profession. Between 2006 and 2017, he served in several acting judicial appointments in the Gauteng Division of the High Court before his permanent appointment on the 1st of January 2018. From the bench, he has continued to demonstrate the same clarity of thought, calm authority, and deep respect for constitutional values that have defined his entire career. Amongst his notable judgments is his 2023 ruling on load shedding, where he affirmed that the state bears a constitutional duty to protect essential services such as hospitals, clinics, schools, and police stations from power interruptions, a decision that underscored the judiciary's vital role in safeguarding the rights and dignity of all South Africans. Judge Davies also contributes to broader conversations about governance and constitutionalism through his work with the Rule of Law Project, where he continues to champion principles of accountability, transparency, and the supremacy of the Constitution. Colleagues, he stands as a reminder that the law is not merely a profession, but a calling, one that demands intellect, integrity, and enduring sense of justice. His career reflects a life dedicated to those ideals, and it is a privilege for us to learn from his example. Judge, you have the floor.
Thank you, Mr. Wadi. Thank you, Chair. Before I actually address you, I think there's one thing which I noted previously in all the accolades that you bestow upon me. I think there was some confusion at some stage between summaries of curriculum vitae between myself and another Norman Davis who practiced at the Johannesburg Bar. I never practiced expropriation law. I did a lot of insolvency law, which might have resulted in some expropriations, but my principal practice was commercial insolvency and constitutional law. We'll have to remedy
Apologies for that, Judge.
in the next time somewhere. If I were to say something this evening, which some of you have heard before, because I've spoken a lot about mediation and the directive and the protocol in the Gauteng division, please forgive me. And as I said the other day at a similar Q&A session at the Pretoria Society of Advocates, and if you have heard what I've said before, but you've forgotten it, then I'll forgive you equally. So a lot of the topics, or a lot of the themes, or principal theme of addressing meetings such as yourself in the past month or two was whether the mediation, the Managed Mediation Directive was sufficiently in support of restorative justice, or whether it was only a case management tool. I need not address the mediators in the room about restorative justice. Let me start out by saying the following. The Mediation Directive had in mind the judiciary's response to a problem which we saddled with and which was not our own, and that was largely RAF litigation, and that was the larger volume of the burden on our resources. That resulted, as you all know, in large volumes of matters on the daily trial roll, and a number of those in any event either settled or proceeded by way of default judgment without no real triable issue identified. So the Case Management Directive requiring managed mediation before you can get a date on the trial roll has resulted in the following case management success, in that our daily trial roll in our division of about 50 matters per day on the trial roll, having been reduced to about 10. I largely speak about Pretoria because not only because I'm mostly based there, but the volume problem was more acute in Pretoria than in Johannesburg, and still is. So from a case management perspective, requiring or ensuring that only matters with triable issues and real disputes end up on the trial roll, that was a success, and that has cleared that role. I'll get just now to the downgrades thereof. What we've also seen, and I say seen by personal experience, often doing the roll call in our seat of the division, but also seen from reports from the recognized mediation organizations, those are the ones recognized in terms of the protocol, is an increase in mediation, an increase in mediated matters, if not always in RAF matters, but in a large number of other matters. And I've received at least from the 20 recognized mediation associations reports from at least 8 who all indicate, firstly, that there are mediations taking place, they are successful, and they are on the increase. The added benefit, of course, is the need for mediation created more scope for new mediators to be qualified, and that also takes place. So the primary objective of the directive has been reached. Let me get to the downside of it, and I'll preempt the downsides right in the beginning and maybe deal with some questions. The downside is that there's still a large number of parties, notably the RAF, who don't respond or respond positively to a Rule 41A notice. That results then in a party, the aggrieved party, approaching the SIC court for a compelling order. Unfortunately, this has resulted in a large volume of SIC matters. While being candid with you, there are currently more than 3,000 of them pending, which was a deluge beyond initial expectations, although we capacitated that court a bit. And I'll deal with how we deal with that at the end before I take questions then. The second problem is, even if a compelling order has been granted and has been served, there is still a large number of unresponsive Rule 41A notices and orders, which entitles the aggrieved party to, of course, be transferred to the default judgment role. Now, the default judgment role in respect of matters which already had a trial date in 2025 and 2026 will be given a default judgment date within 6 months at the latest of the lost trial date, if one can call it that. That's not the biggest concern, and that is being dealt with, although it is still onerous on our judicial resources. The other issue, and I'm sure a lot of you will have questions about that, is in matters which had trial dates beyond 2026 or did not yet have trial dates. We've now found that our registrar allocates those, but tags it on at the back of the previous default judgment roll. So some of you might, to your large frustration and huge dismay, have found that you've been allocated default judgment dates beyond 2030. and sometimes if rumor or if the references are correct, 2031, 2032, and 2033. I'll deal with those problems, but let me deal with those in the SIC problems right now. We are aware of these problems. We are aware of the accusations that this only means that a trial role has been shifted to a different court and a different role, but the problem still remains. To an extent, that is true and correct, but it's not a problem we caused. It's one which we're trying to deal with. We have heard some positive responses from the RAF, but not nearly sufficient enough. We have written to the minister because it's unfair of us to just expect practitioners to come and act on a pro bono basis. And we've motivated our request to the minister based on these figures I've now mentioned. So from the first term, next term, we have, in addition to the acting judges we already have, we have an additional 16 paid acting judges posts. And we have, we're still in talks about it, so I can't give you the final proposition yet. But my proposition to the AJP is as follows, that we run an additional 3 courts per day of 50 SIC matters per court. So that'll be another 15 judicial court days per week that we need. And if we do 50 per role, that will be 750 SIC matters per week. And that will assist us to, in the first term already, address the initial backlog of 3,000 SIC matters. The default judgment ones, we haven't gotten that formulation. Oh, sorry. And the SIC roles, then the proposition is that to not overburden the judges, because we increase now the number of the roll from 30 or 40 to 50, is to have them sit in a similar fashion as in the unopposed motion court. So say judges 1, 2, and 3 will sit on Monday, Wednesday, and Friday, and judges 4, 5, and 6 will sit on Tuesday and Thursday. So they each have then reading days to prepare for that, and that'll be the proposal for the term. On the default judgment ones, as I said, there's not yet a formulation as to how it should be, but my proposition made to the AJP is that I find it not, I don't find any justification for a default judgment date going beyond a year. That means that all those allocated up to 2031, 32, 33, we will have to devise a way in which they can be all dealt with, hopefully in next year. The pre-existing ones have already you've seen being given dates earlier and brought back, but that program must increase. We're aware of it. We will address it. How? I don't exactly know, and all suggestions, of course, will be welcome. Having said that, as an introduction to the Mediation Directive and the current state thereof, let me just, if I may, briefly, for those of you who might not have had the opportunity to go through the amendments, deal with them quickly. Amendments to the directive and the protocol were devised. It was after discussion with many of the practitioner organizations, such as yourself, and also the RAF. You will recall that the initial directive said all trial matters must be mediated as an imperative. For a change, and I say that to their face as well as behind their back, the RAF came with positive suggestions which were incorporated. And some of these suggestions I urge you also to take into account and not have an institutional bias. The RAF, for example, said, but Judge, how can you force us to mediate a fraudulent claim? We've done our investigations. This is a fraudulent claim. We can't mediate it. And we said, you're right. Fraud should be determined by a court. But if you as practitioners say, no, that can't be, there can never be any fraudulent claims, then the RAF said, well, there are some other claims which are difficult to mediate. For example, a plaintiff sometimes goes from one attorney to a next, for various reasons. Perhaps he did not get sufficient service, or it took too long, or just because of opportunism. And then the RAF said, but if we now get a notice to mediate, and if we miss that, and even if we get a compelling order to mediate, Our response is, but this claim is a duplicate claim. Then they go further and they say that some of those duplicate claims have actually the first claim been settled. So we can't mediate the second one where the first one has already been settled. Some of them go further and say there are instances where they say not only is this a duplicate claim, but the first claim was settled and already paid. So one of the amendments you'll find in various paragraphs in the directive 13, 17, and 19 makes provision for a joint minute and or a directive. Let me summarize that. The amendments to the directive regarding trial dates are the following. You can now get a trial date in one of three ways. One, if you've attempted mediation and it was unsuccessful and you have a mediator certificate to that effect. Two, if the matter, because of the nature thereof, can't be mediated, such as a fraudulent claim, then the parties must meet each other, formulate that in a joint minute, and the proposition is that in the joint minute, the dispute be delineated to what caused the matter not to be able to be mediated. And from a proposition from DJP Sutherland, which is also then included herein, if it's only something like in the nature of a legal question, such as prescription, then you will be entitled to formulate that as a stated case and even have it argued on an opposed motion court roll. So that's the second option. And the third option is then if you are allowed to approach the registrar for a trial date by way of a directive from either case management judge, which would be either in the commercial, in terms of the commercial court rules, or another appointed case management judge, or one of the mediation umpires. So three ways you can get onto the trial roll, and only those three. One, a mediator certificate. Two, a joint minute. Three, a judge's direction. Now, in respect of the umpire, when I mentioned that, the directive in the republication, we mentioned the names of the umpires, and then in case one of us might be away or in a different court or whatever, there are now centralized email addresses to which one can send, by way of a letter, need not be a formal application, the dispute to the umpire. So there's an email address for the umpires in Johannesburg and an email address for the umpires in Pretoria. I have this afternoon just checked my reports. So previously the protocol only made provision for the following: that the umpires can determine the appointment of a mediator where there's a dispute about the identity of the mediator. That has now been extended in the protocol, that the umpires can also make determinations as to the soundness or cogency or validity of a Rule 41A response, or can immediately then say, well, you need not otherwise attempt mediation. You've convinced me this is a prescription matter. Here's your directive. You can go to a trial court. I do about 2 to 3 mediation dispute appointments per day, and about 5 other disputes per day regarding cogency of Rule 41A responses. I mentioned that to indicate that I have in Pretoria 2 assistants, and of course there are 2 others in Joburg as well, that if it becomes too many, then I farm them out to some of the others. One is just to check that the farming out doesn't cause a longer time delay. But those decisions by the umpires, by way of correspondence, a letter, of course a complete letter with other side's notice and response therein as well, gets responded to by way of a directive very, very soon, within a short period of time, without the need to approach the SIC court, and without the need of going through that costly or difficult or delayed process. So that's another innovative amendment to the mediation directive and the protocol. A last thing I want to mention about the protocol was, last 2 things. So say a party has gone to the SIC court and has obtained a compelling order, and the compelling order has been served and there's been non-compliance with it. And now upon production of an affidavit confirming the non-compliance, the aggrieved party can now apply for and get onto the default judgment role. Now, parties then said, but the default judgment role, must that be a full application? Must there be extensive papers? What about the cost of that, etc.? We've clarified that in the directive to say your default judgment application must be an application, true enough, but it can be on notice. So you need not have a rule 2A and a long notice. It can be on notice. You can have almost a 2-page, 3-page affidavit because you're entitled to refer and incorporate the documents already filed. So you can, for example, say, I'm the plaintiff. Here's proof that the compelling order was not complied with. I'm entitled to default judgment. I will rely on the reports already uploaded as A, B, C, E, and F, and also the section 19.1 affidavit, which can be found there. And based on a combination of those, the evidence, merits and quantum, I'm entitled to an order, which brings me to the point of merits and quantum. The formulation in the directive which says at the default judgment you can move the merits of your matter, which meant everything, was a formulation by Judge Sutherland, and it seemed as if the practitioners and those used to third-party litigation were so used to the parlance of separating merits and quantum. They said, well, what about quantum? Quantum was intended in that directive, but insofar as it may not have been clear, it is now clear in the amendment to paragraph 4.9.3 that you claim substantive relief in the default judgment court in respect of both the merits and the quantum of that party's claim or defense. So that's the other clarification and innovation in the directive and the protocol. And of course, then the full provision for the joint minute scenario I mentioned earlier as the second manner of getting onto a trial roll has been encapsulated in a new paragraph inserted in the protocol as paragraph 7.1 capital A. So in a nutshell then, Chair and practitioners, that's the state of play. The mediation directive will be in force. It has been successful regarding the trial roll, the consequences thereof, or the negative fallout on the SIC role and the default judgment role, we are aware of, and we will address it. And we hope that the other amendments will assist practitioners in dealing with the mandatory mediation issue. A last aspect before I close. Remember when I started, I referred to the issue of restorative justice or just case management, and I've now primarily dealt with the case management consequences. Restorative justice, for those who actually do mediation, understand that it means that the wrong that has been caused is now restored by way of an agreement, which need not follow legal lines, which need not follow determinations of merits or contributory negligence. It may, but it need not. It can just end up at an agreement where the parties are both happy with it. And for that purpose, I am still daily astounded how practitioners exclude, particularly plaintiff practitioners, exclude their plaintiffs, their clients, from this process. All the poor client here, the same as in the court action, often is, oh, there was a settlement on XAZ, or here I've mailed something to the correspondent, please go and sign somewhere. But he's rarely made part of the process, even if it entails difficulty in costs and time and distance. It is imperative that he should be there. And if the distance is a problem, well, perhaps one could consider then instituting action in all jurisdictions where the delicts occurred, not in Pretoria, but that's only an aside. But the restorative justice issue, I feel, is sometimes overlooked by practitioners, and it's sad to say also plaintiff practitioners. Chair, I think that's all that I had to say so far in introduction, the state of play of the directive, the consequences, positive and negative, and also the amendments so far. I hope that it might be an optimistic hope that some of the questions have been preempted.
Thank you so much, Judge Davis, for those kind remarks. And that summary of those amendments, I think it really does provide a lot of clarity, and we're glad to see that those amendments did come through. And we've circulated those documents not ahead of this particular webinar, but it's available on the various associations within Gauteng. You would have received it if you remember, but we are also going to be making it available on our social media. So for all of our guests who are joining, you can go onto LinkedIn and check on the various associations, and by this evening you'll be able to access those very important protocols that we need to adhere to. Now, Honourable Judge, I am going to see if we have any questions. I'm going to remind those that are joining us, if you have any questions to address to the Honourable Judge, who's kindly availed himself and hopefully has addressed a lot of your queries with his address this afternoon. Could you please raise your virtual hands and we will welcome you. When you are acknowledged, you can turn your camera on, unmute yourself, and you'll be able to do that. And then also we're going to ask if you could just start off by introducing yourself and confirm the name of your law firm, if you're comfortable, before then starting with the question. And if you're unable to mute yourself, there is a chat function as well, which we will be monitoring if you have any questions in there. And while we're waiting for the hands to roll up, I did want to share, Judge, that last month at the Johannesburg Attorneys Association, and I'm sure with Pretoria as well, they identified quite similar things. When delivering my chairperson's address, one of the things I had to do was summarize reports from our different committees. And one of the positives that we've seen from the High Court Committee, acknowledging the challenges that the mediation protocol brought, we also saw the positive to the backlog, where we had our High Court Committee reporting that settlement and the steps of the court have reduced. And some of those details are outlined in sort of our chairperson's report at the Johannesburg Attorneys Association. And I know Pretoria has been working quite extensively on this as well. So thank you for that. It's not all doom and gloom as we've seen over the first few months of this mediation directive being implemented. It is new ways of working, and there's so many different ways that you know that we've had discussions on other new ways that we're learning to cope with. I'm just having a look at the chat, and I'm having a look at hands being raised, and there is stunning silence, which means for me, Judge, yes, you're welcome to put your question into the chat, and I'll read it out. So I think, Judge, you've addressed a lot of questions with your address.
Maybe not, Mr. Wadi already has one.
Thank you kindly. My name is Yusuf Wadi again from Wadi and Wadi Attorneys, as well as the Gauteng Attorneys Association. We've had a EEC meeting in Johannesburg, whereas a question that came up directly on the delinquent parties portion. The question that arose from the meeting was simply, when bringing an application against a party, against a delinquent party, can that be incorporated in the court order in a single application that if the defendant does not comply within X amount of time, may they then proceed directly in terms of the practice directive through to default judgment? Alternatively, is it a prerequisite that a second application be brought once a delinquent party has not complied within that time period for a second TIC application to then proceed by default judgment? Thank you, Judge.
The answer is yes. Sorry, the answer is no. Initially, one that was a slip. Initially, the thought was that one would have to come back to court, but we tried to skip that, and we had long debates when this was formulated. So it's a single process. So you go to, let's take a Rule 41A, and let's stick with mediation for the moment. And you go to the SIC court and you get a compelling order to compel a proper response or to compel after response participation in mediation. Upon default, well, the order should read that you're entitled upon default, and the protocol says on proof of affidavit, to then immediately go to the registrar to say, I had my compelling order, here's proof of service, the DAs have expired, here's my affidavit to say I haven't had a response, give me a date on the default judgment roll. Your second procedure is in that court. And in that court, by way of an application on notice, you can then ask for either a striking off, but you're on default in any event, does not mean that much, or depending on the circumstances, you might need one. You can ask for contempt of court as well, if it might help, say, in respect of a prior order for not delivering an undertaking, and you can ask for your findings on your merits. We can ask for Rule 38 application and a finding on the merits and a finding on the quantum and the totality of the relief, including then punitive costs. So you need not come back to the SIC court for a second time. But what we do not want to put in our SIC orders is that a person is ipso facto in default, because that means automatically. And so it must have a step to say, here I am, registrar, here's my affidavit that the person is in default. Ipso facto might sound as if it takes that away. So short answer, only one application to the SIC court if it's Rule 41, and thereafter to the default judgment court. I might also interject at this stage as well. I sat in the SIC court the other day just to gauge what's happening there, and I told some of my colleagues they should. Well, no, I can't tell them how they should approach matters or how they should exercise their discretion. But we discussed the nature of matters. I'd like to mention two things in that regard. The one is, if you go to the SIC court for a compelling order for a 41A application, you'll get that and your referral to the default judgment court as per the protocol. If you go to the SIC court and you seek there a striking out of a claim or a defense for something more substantive, such as a failure to attend to a date where the registrar has directed a date for a pretrial conference, or having attended a pretrial conference, persistently refusing to give a response to your answers or to adhere to your undertakings to give certain answers or documents, etc. That's of a more serious nature. Then you can ask for a striking out of the defense, irrespective of whether there'd been mediation or not. But the corollary of that is when I say you can ask for a striking out for non-compliance of a substantive matter, which might have brought the matter to a close or bring the matter closer to finality. If you come to the SIC court and you say, and I mentioned this to practitioners as an example, which happened more than once per week in the past month, and you say to the court, look, I've given notice to make discovery to a defendant such as the RAF, and I did so in 2015 or 16 or 17 or 18, the normal Rule 35(1) notice. And subsequent to that, there's been a settlement of the merits, there's been an undertaking, there's been various issues, and now suddenly you want to engineer a default judgment position by coming in 2025 to say, the matter can't proceed, can't go forward because the RAF hasn't given me a Rule 31 discovery, which I can't tell the court actually whether it'll be a special or exceptional case and so on. Then we all know that you're opportunistic. We all know that, that the rule is being used for purposes of obtaining a default judgment position. It's not being used to obtain actual discovery. Then you might run into difficulties in the SIC court.
Thank you very much, Judge. We've got a few more questions that's come in. We've got a hand raised and we've got questions in the chat that I'll read out, some that were directly sent to me and others into the wider chat. So I will be reading them out. I think just for purposes of discussion, we've dealt with the first, Mr. Wali's question as a verbal question. Conference 2, before I get to you, I'm going to deal with one question in the chat and then we'll go to conference 2 and vice versa. So this question was sent to me privately a little bit earlier, says, the protocol provides that unless agreed to to otherwise between the parties, professional fees will be paid to the appointed mediator, as the case may be, by the parties jointly. What is the position if your client does not have the financial ability and does not place the attorney in funds?
Well, we've also wondered about that question when we formulated the directive and the protocol, and at the last and second last meetings, where there were about 57 stakeholders, virtually every single mediation organization has confirmed that there will be members of them that will assist on a pro bono basis in meritorious or indigent cases. And they've repeated that subsequent to that. So I would urge such a party then to say, look, it's really one of those where I can't fund as practitioner the client anymore. I was on contingency up to now paying the doctors, but yeah, this is just the last straw. I would urge such parties then to approach a mediation organization itself, if you can't approach an individual mediator, and say, this is one of those cases where you promised Judge Davis that you will make a mediator pro bono available. Please do so.
Thank you very much, Judge. I'm now going to acknowledge Conference 2. If you could please turn on your camera and mute yourself and introduce yourself.
Thank you. Good afternoon, everyone, and thank you, Judge, for taking the time. I'm Azhar Aziz-Ismail. I'm an attorney that practices in Pretoria at Johan van der Vyver Attorneys, not Conference 2. Judge, if I may, I just have a question regarding the role of the opposed motion court. What we find is mostly in RAF matters, the RAF would, for instance, in foreigners' claims and in matters which we call the ML matters, which are being refused to be registered in terms of the board directive, and in matters where we have not, for instance, filed all and every single report, but the merits remain contentious, refuse to mediate. In those circumstances, if I obtain a joint minute from my colleague wherein we agree in the circumstances that we're unable to mediate, may I then approach the registrar for a trial date in the normal course? Or am I obliged to then first follow the route of the opposed motion to have that dealt with before I'm entitled to a trial date?
Well, you can approach the... Sorry, thank you for the question. No, you can approach the registrar directly for a trial date. We also hope that the issue of this board directive will be soon finalized. I understand it's already been argued, and we're awaiting a response from the SCA. On the non-compliant issue of the forms or the lodging of the claim, that is one where I think one can more fruitfully in the joint minutes say, this is the contention. Was this document delivered or not? Or was this the reason why they say it is non-compliant? If one can formulate it in such a fashion that you can get to a stated case, then you can go to the default judge, to the opposed motion court. If not, well, then you're entitled to go to the trial court.
Thank you, Judge. And whilst I have the floor, just one more question. We, as you've mentioned, the SIC role is quite congested, and I need to give feedback, obviously, and report to my clients. And I think we, as attorneys and plaintiff attorneys, are taking a little bit of abuse from our clients because the process seems to be halted. And I'm very grateful for the appointment of further judges to deal with this issue. What is the expected lead time? Because I have SIC applications that were lodged in August and September this year, where we have not yet received an SIC date. Now, I see the notice is made of 4 weeks lead time in the directive, and I'm not sure whether it should be 4 weeks from date of application and everything being lodged, or is it 4 weeks from the registrar considering it. And I have compassion for the position that the registrars find themselves in and the whole system, but I have at this point in time no clarity as to when the matter can be escalated, can it be escalated, and what is the expectation if I don't have a date within 4 weeks? What is the process to be followed thereafter? Thank you, Judge.
Aim will still be 4 weeks. Those of August and September that you don't have, those form part of the three 3,500 backlog. So they will firstly be addressed in the first term. And thereafter, because if we can get the position, as I now mentioned, that we can do 750 per week, then by halfway through the term, we should have dealt with a backlog. And from then onwards, or at least if anything goes wrong, from the end of term, the lead time of 4 weeks should be attainable and is our aim.
Thank you, Judge. Thank you very much. Thank you, everyone.
Thank you very much for your question, and thank you, Judge. While there aren't other virtual hands, we've got a lot of questions that have been making their way into the chat. Some comments, mainly questions. So I'm just going to read the first one out, which comes from Tabo, which says, did the court perhaps consider the possibility of applying the Gauteng Division Mediation Protocol to newly enrolled matters, where a trial date is still to be allocated, rather than applying it to matters that already have trial dates assigned? This is particularly pertinent given that litigants were advised as early as 2021-2022 that their matters had been allocated trial dates in 2026. In addition, given the delays experienced to date, if a new trial date is only allocated after compliance with all procedural requirements under the protocol, there will likely be a need for an addendum or addendum medical legal reports, which will further increase litigation costs and place an additional burden on the parties. Retrospective application of the protocol under these circumstances may therefore result in unnecessary prejudice and procedural inefficiency.
Yes, well, firstly, the initial indication was if you introduce a new mandatory regime, you must deal with the matters already on the roll. And those were 25, and then later, 2026. You'll see the amendment also said that all the 26 matters, not initially the directive only said if you don't have you must go through mediation, and if you don't have a certificate, well, then it'll be removed. But it's been added to now. But if you had a matter, try to mediate, couldn't mediate, or if it goes by way of default judgment, you'll get a date within 6 months of your initial date. For the remainder, our aim is still then to have a lead time of, the ultimate aim will be a year, that if you apply in January, you will be heard in that year. So it's right, we are aware of the possible staleness of reports, which should be avoided. So for those matters not yet a trial date allocated, but if you go through the motions and you then unsuccessfully mediate, we want to give you a date then within a year. Currently, though, I can also mention you that the lead time for trial dates have been so reduced that if you now go to the registrar this week and you say, here's my mediation certificate, or here's my directive from an umpire, or here's my joint minute, give me a date, you should be able to get a date within the second term of next year.
Thank you, Judge. Very interesting, and congratulations on bringing down that long lead time for trial dates. Next question comes from Krumisa, and it's a point of clarity. How does one deal with a situation where one party does not want to mediate and they have provided reasons? Is the joint minute sufficient?
The reasons are cogent reasons. And then, of course, one has to say, well, say, for example, prescription. And it has to be determined. And that can't necessarily be mediated because there can't be an agreement. They're irreconcilable poles. Then we thought that at least that dispute can be separated from the remainder and formulated. If not as a stated case in the opposed motion court role, and you need to lead evidence, then at least it's a distinctive point to say, we can mediate the remainder. We might even be able to, on the hypothetical case, that there is no prescription, agree on the quantum or a way forward or a determination of some of it. But we first want to make sure whether it's prescribed or not. And you set that, only that down, then that should be in a joint minute and be set down. And that is also why we don't want a long lead time, because something like that should be dealt with upfront and quickly. So if, however, on the other hand, the aggrieved party feels that the response to the mediation is not a proper response or is not a cogent reason, the party can either approach the SIC court to say, by way of a 30A notice, to say this is not a cogent reason, give me a cogent reason. Otherwise, I'm going to go to the SIC court and ask that your defense be struck out, ask that you be declared a delinquent party, and I go to default judgment. Or you can even, the protocol makes provision for it, you can even approach an umpire to say, umpire, please save me the cost of the SIC court, determine whether this is sufficient or not. The umpires will then do one of two things. It will either say this is an insufficient reason, the party is delinquent, you can go to the default judgment court, or the umpire can say it is a proper reason, formulate the dispute and then go to the trial court, or the umpire can say it seems that this needs more argument. For that purpose, go to a judge in the SIC court for determination. So if it's a proper reason, formulate a joint minute, go to the trial court. If it's not a proper reason, see whether you can deal with the fact that it's not proper by way of a 30A notice, or approach to an umpire or the SIC court directly.
Thank you very much, Judge. Nicolette Devitt, I acknowledge you for the next question, and then we'll move back to the questions on the chat.
Thank you, Mr. Chair. Judge, I have one or two questions for clarity on the interpretation of some of the sections of the directive. So the paragraph 4.9 dealing with delinquent parties says that one of the orders that a court can give is an order that parties are excused from mediating. It's one of the first subheading, if I remember correctly. Yes, paragraph 4.9.3.1. So it says, should the delinquent party fail to comply with the compelling order contemplated in paragraph 4, blah, 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 within the time provided for, the aggrieved party shall, upon production of non-compliance by way of an affidavit, then that paragraph says, excused from not subjected to mediation. Now, I know that we've been advised at the beginning of the directive, on the April version and on the later amended version, that there should be no orders in the special interlocutory court saying that you can retain a trial date. But with this paragraph, not by implication, say you're now excused from undergoing mediation, would that not entitle you to ask to retain a trial date?
But absolutely not.
Judge, yes, thank you. Can you elaborate? Because I've been, there are judges. Yes.
No, it means that you need not further attempt to go through mediation in order to get a mediation certificate, to go to the registrar to get a trial date, but you can't retain your previous trial date.
So the appropriate.
Let me explain. If you now were to retain your previous trial date, you'll undermine the whole import of the mediation, because you now want to retain your trial date to run a default judgment on a trial court with no identified triable issue and with no opponent. That kind of scenario is a default judgment scenario, and therefore you're excused from further mediating in order to get a certificate, but you'll have to get a new date, and that date will be on the default judgment court roll.
Thank you very much for clarifying that, Judge. I think there was uncertainty about that aspect. Then, just one other point for clarification. If we look at the directive itself, and I'm at paragraph 17A, to which you referred to earlier, which specifically says that if you've lost your date in cases against the RAF in 2025 to 2026, you'll get a new default date within 6 months after the date that you've lost.
Yeah.
It seems upon first glance, and I might be missing something, that's why I'm asking for the clarification, that there's not a similar paragraph dealing with non-RAF matters that's on trial for 2025 and 2026. Where is there something like 17A that also applies to paragraphs 18 and 19 on the non-RAF matters, or do we find that elsewhere in the directive?
The RAF matters generally did not have such long lead times and were easier slotted into a trial role and will similarly again be easier slotted into a trial role. RAF matters were large in number and had long lead times, and the introduction of that 6 months was in order to meet the objection against the directive to say, but we've waited 5 years for a trial date because there are so many RAF matters, and now you want us to wait another 5 years. To say, no, you've waited 5 years, you're right. If it now becomes a default judgment one, because we said it's no triable issue, you won't lose more than 6 months.
All right. Thank you for clarifying that, Judge.
Thank you very much for your question, and thank you, Judge. Before we acknowledge the next hand raised, we're going to do another question from the chat, and then I'll come to the hand raised. So, looking at the chat, the next question, just see here. Okay, good day. I have a question on what steps to take when the defendant replies to the Rule 41A but does not sign the first pretrial minutes, or signs the pretrial minutes but does not select a date mediation, time periods. That is the question that was sort of put into the chat.
Sorry, Azhar, just read that question again.
I'm going to read it again. Good day. I have a question on what steps do you take when the defendant replies to a 41A but does not sign the first pretrial minutes, or signs the pretrial minutes but does not select a date mediation, question mark, and then time periods.
On the first part of the question, I assume that the response referred to there is a positive response to say, yes, we agreed to mediation, and yes, we will agree to a pre-mediation agreement, and we even agreed to your proposed mediator. If that's the answer you get, well, now you go to mediation. Why do you care about the pretrial at all? You're going to negotiate, not negotiate, you're going to mediate. You're going to meet each other and discuss all sorts of questions and agree on certain aspects. If something can't be agreed on, one can even agree on the pretrial answers or pretrial questions. You need not mediate the whole matter. You might mediate only merits. You might mediate loss of earnings. You might mediate general damages, or all three. But once you get to mediation, why are you bothered about the pretrial answer? If you, however, have a response to agree to mediation, and there's a mediation agreement and an agreement on the mediator, but thereafter the party becomes recalcitrant and does not participate in the mediation, then your approach is to the SIC court. But now you won't seek an order compelling a response to a 41A notice. You'll seek an order compelling participation in the mediation by, for example, attending within 10 days notice, say, for example, the next date determined by the mediator. So it's slightly different, but the protocol envisages then a recalcitrant or delinquent party in the mediation process as well. Currently, we see a lot of the delinquency, the delinquency regarding responses to 41A, but it can also be delinquency regarding the process of mediation, which has already commenced. But again, once you're onto the mediation train, you want to mediate this matter to the satisfaction of your client and the other side and with a positive outcome. A pretrial answer is by the by. Many practitioners, I think, still see mediation as a legal mechanism. It is slightly different. It is participation in a voluntary process which may or may not have any bearing on the percentage of contributory negligence or any bearing on a non-response to a pretrial question. So that's my answer. The answer is, if you're going on to mediation, you need not be bothered that much about the pretrial answers. If you're going on to mediation and halfway through a party doesn't participate, well, then you can get a compelling order, compelling participation in the already commenced mediation in the SIC court.
Thank you, Judge. There was a comment made, and then I'm going to go to our first hand raise. So the comment was made from Marion, who said the point about restorative justice and how mediation allows the parties to process the conflict and find a way through it and put it behind them is a reminder that mediation is so much more than a tick box process. Thank you for reminding us of that. And with that,
Chair, if I might respond to, I might just add to that. I saw there was another chat as well, which says practitioners still think that the mediation is a legal process. Mediation is, as Marion said, it's a restorative process and it's a voluntary process of seeking solutions. It's a difficult switch sometimes for practitioners to make, but in other jurisdictions, we've seen even litigation firms make the switch to become mediation firms and make the same amount of fees with happier clients and in a quicker turnaround time.
Thank you, Judge. I'm now going to acknowledge Adi du Toit. If you want to come on camera, please, and unmute yourself.
Thank you very much. Good afternoon, Judge. My name is Adi du Toit. I'm from Gauteng Attorneys. I am also a certified mediator. My question is quite a simple question. The question comes whether a party can compel another party's payment of the mediator's fees. Now, the reason why I'm asking is there was a particular matter that I'm dealing with where the mediator was not necessarily recommended, but it was merely stated this particular person will be the mediator at a fee that was, in my professional opinion, not a fee that should be that particular or should be that high for the particular matter. The response was then to state, well, we don't necessarily agree to the mediator, and the parties didn't engage in any conversations regarding which mediator would be appointed. The response simply came to state, well, then an SIC application will be launched to compel the payment of your portion of the mediator's fees, which I feel is irregular, but I believe from an interpretational perspective, it might be worthwhile just to address that particular aspect. Thank you very much, Judge.
My response, without now having sat down and considered the matter, would be that the mediator itself, the person, and the fees often go hand in hand. And if the one, say it's a chief mediator, but well, to use that word loosely, say it's a very affordable mediator, but the parties can't agree on the person of the mediation for some other reason. Say, for example, the person is an RAF mediator and this is a family matter, or other way around. It'll be the same, I think, if the person is an acceptable mediator, but the fee is not. I think then one will be in the position to say that parties do not agree or can't agree on the mediator. I would then suggest the answer is to say, well, we can't agree on this mediator, or we can't agree on this mediator at this fee. Seeing we have this agreement, let's each propose 3 other mediators we know the fees are fine. If we can't agree, we'll go to the umpire, and then we'll have to live with who he chooses from a list. But with a proviso that this is the fee that our clients can afford. So I think the short answer to your question is that will result in a non-agreement to a mediator. I think one need not go to the SIC court, and you can go to an umpire for determination of a new mediator.
Thank you, Judge. And then just to add on to that answer, what would the position now be if the opposition then would proceed with such an SIC application? Because surely the SIC judge who hears the matter won't necessarily be able to make an order compelling fees if you haven't proceeded with the necessary procedure.
If you were to say everything I've now advised as a view of the matter in an answering affidavit to the SIC court, well, then there will be a question to be determined by that judge.
Perfect.
So
thank you very much, Judge.
The SIC court proceeds generally by default, either default of lodging papers, opposing papers, or by default of appearance. But it need not be so. Any party can appear. And let me also just add that in while we're talking about it, the protocol and the directive were both formulated in neutral terms. So a defendant can also be an aggrieved party.
Thank you very much, Judge.
Thank you for your question. And Thank you, Judge, for the answer. Before we carry on to the next question, I am mindful, I don't want us to lose everybody. And a question that I've received once in a major chat and a few times in the private chat from a few participants. Judge, I am going to ask you to indulge this question and maybe just clarify for the users who have raised the question, what is an SIC court for those who are unaware?
Sorry, what is an SIC court?
Yes.
Well, actually, we've retained both names. It's either an SIC court or a TIC court. So it's either a special interlocutory court or a trials interlocutory court. We've retained both names because they have both historical issues. I think in Joburg or in Johannesburg seat of our division, they more readily refer to it as a TIC court, the Trials Interlocutory Court, and in Pretoria more often to the Special Interlocutory Court. That's how it features on the roll as well. But it is the same court. It's a separate, dedicated court staffed by no less than 2 judges. And of course, as I said, for the backlog, it might be an additional 3 judges every day of term, dealing with matters, all interlocutory matters, and matters arising from the directive and the protocol. So it also deals with other interlocutory matters which are not dealt with otherwise by way of case management.
Thank you for the clarification, Judge. And I hope that addresses a lot of the questions that we've received in different forms of chat. Before I continue and acknowledge our next question, I do want to raise that for those who do need to leave, we do understand that, and a recording of the session will be made available on the Gauteng Attorneys Association's YouTube channel. So, with that, going to acknowledge the next question, which is a virtual hand raise. Mr. Conrad van der Vyver, would you like to please unmute yourself, turn on your camera if possible, and you can now introduce yourself. Thank you.
Good afternoon, Judge. Conrad van der Vyver van Gauteng Attorneys. Thank you so much for taking the time to answer a lot of questions, which I believe is extremely valuable. The one thing that we have noted is that you obtain an SIC order for a delinquent party to, within 10 days, say, refer back and give a reply in terms of your amplified notice. They do so, let's say, on day 8, day 9. Then you follow the process of sending a joint minute, but they then never send back a signed joint minute, or then further, they send back a signed joint minute and they never sign an agreement to mediate. Is it the intention of the directive that you then have to vent yourself towards the SIC court in every instance from there on forward where there is non-compliance, as there is it's a dual step program? Or if a individual is then declared a delinquent party, they are then declared a delinquent party? Thank you.
Fortunately, Mr. van der Vyver, you'll have to return to court because it's a separate delinquency. The first one was not giving a notice, and the second one is having expressed an intention to mediate, then not participate in it. Your second approach to the SIC court, I think you might coach that wider to say they must be compelled to sign the agreement, appear, participate in the mediation, appear at the dates, etc. So hopefully it will only be then a second step and not 5 further steps. I think the second step after party has consented to mediation can be a composite delinquency. But initially, it's just to get a response. Because the response can be yes, no, or cogent reasons. But once there is a positive response, then there must be participation. That participation can take many forms. So the short answer is yes. If a party is once indicated to mediate, well, then he's complied with the first compelling order. So there must be then an application dealing with a second non-compliance, a second delinquency. But that can be in that order. You can make provision for any future further step in the mediation.
Thank you, Judge.
Thank you for your question, and thank you, Judge, for the answer. The next question in the chat. Thank you, Judge, for your time. In relation to the new joint minute procedure, I note that the procedure provides that parties may approach the opposed motion court in relation to same. where both parties agree and are able to make a stated case in the joint minute, is it a requirement that the parties approach the opposed motion court, or is the stated case in the joint minute sufficient to approach the registrar for a date? Thank you again for your time and information.
Thank you. No, we made it permissive. The customary position would have been, if it's a matter which is not capable of being mediated due to the nature of the dispute, say, for example, prescription, then one would have to go to trial. But then there might be instances where the prescription issue even might be on an interpretation of a statute where you would not need evidence. Then it can suitably be done by way of a stated case in the opposed motion. But we can't. And we've debated this, DJP Sutherland and I, between ourselves. There was initially a different formulation to say it must be a stated case. And I said, well, even if it's prescription, what if someone wants to lead evidence? And we don't want to force parties to go to an opposed motion court and then have to ask for oral evidence or a referral. So it is permissive. It is permissive depending on the nature of the dispute and how the parties can formulate it or agree on the formulation or agree on the facts. Remember, in a stated case, there must be an agreement on the facts on which the question to be decided is to be determined. If there's no agreement and there might be evidence or different facts, or the facts might be in dispute, we will urge the parties to formulate that dispute, but that will probably have to go to the trial court then.
Thank you very much, Judge. I'm now going to acknowledge Matome. Would you mind unmuting yourself, turning on your camera, and introducing yourself, and then asking your question? Okay.
I'm trying to unmute myself. Sorry.
We can now hear you.
Yeah, I'm trying to show my face as well. Just to make sure that I'm not a ghost. Am I visible?
There might be a challenge.
Yet, but you're quite audible. It would be preferable if we can see you, but if we can't get a visual, that shouldn't stop you from asking your question if I can assist you with an answer.
Yes. Judge, thank you so much. Judge, I'm not a rough lawyer per se, but I've got this matter where my elderly mother is it applicant? She's an applicant. Now, what happened is that the ref, said that there's no nexus between my father's death and the accident, and her lawyers went to court. The court ruled that there was nexus between her death and the death of my father and the accident. Now, my lawyers went back to RAF, I think for mediation, but the RAF still sent a letter that said there's no nexus between my father's death and the accident. Besides the point that there was a court order that found that there was this nexus. Now, my question is, what is the way forward in terms of because I heard you talking about delinquent respondent. Is it a contempt of court, or what is it that must happen next going forward, the judge? Please, I really, maybe you spoke about it, but can you please just clarify for me what the next step should be? Thank you, Judge.
It's difficult answering a question which is case specific. If I might answer in general terms, if the RAF has previously conceded a point and then afterwards, by way of either a different claims handler or a different practitioner says a different point, I would suggest the parties to try to get together to formulate a joint minute, and perhaps the previous order can then be sorted out in that joint minute. The other alternative is then to go to the SIC court to say, but the response is not a proper response because he has a court order dealing with that response. So those will be my answers.
Thank you, Judge, and thank you for your question, Matome. We're now going to go to the next question. Can the successful party claim mediation costs on taxation?
Well, if You mean, let me just understand the question, is if the question is, can the party in a successful mediation claim the costs? Well, during the course of mediation, one would, of course, agree on who pays the costs and what extent. So I assume the question is, if there's been an unsuccessful mediation and the party goes to trial, whether the party can thereafter then claim the costs thereof. Yes, the Mediation Directive and the protocol did not abrogate Rule 41A and attempted to operate within the parameters of the rule. And that rule makes provision for, at the end of the day, if it had been a trial, and without disclosing to a court what had happened at mediation, but once merits have been determined or the trial has been run, then afterwards one can say to a court, before you make a cost order, I want to tell you the following. We even attempted mediation. It was unsuccessful. A court might say, well, that's cost in the cause if it's unsuccessful, or if a party is armed with a certificate from a mediation to say one party did not bona fide participate in the mediation and the protocol makes provision for it, then that party can ask for the cost of that mediation, and even on a punitive scale.
Thank you, Judge. The next question was a question that our expert received via WhatsApp. Is the RMO model the most efficient and cost-effective model to administer these mediations, rather than the professions doing so?
Well, let me just explain. There's no current umbrella body for mediation organizations. The courts and the judiciary can also not be involved in accreditation of individual mediators or delinquent mediators if something goes wrong. The model then chosen was that we recognize mediation organizations and they administer oversight over their own members. How the mediation itself is administered is by way of actually three aspects, three possible routes. The first one is ADR Tech, suggested in the protocol, and they run, I think, at a 1,500 rand cost of per mediation, the administration of the mediation. So it's really not a large chunk of money. The second one is the administration by the individual RMO, and that I understand can sometimes be a percentage, so it might even be more. And the third one is if the individual mediator says, I am a qualified mediator, I'm a member of a recognized mediation organization, so therefore I can mediate, and that organization will exercise disciplinary oversight over me, but I will take the responsibility of running the mediation and including the cost, fees, recovery, etc. myself. So we did not want to bind any party or any mediator. Either of those routes can be followed. The ADR Tech route is efficient and very cheap. The individual RMO's one is, of course, your own choice to which RMO you belong or want to. The third option, doing it yourself as a mediator, is always still an option. It might just be more risky. So we left the choice open to the individual mediator.
Thank you, Judge. The next question. Good afternoon, Judge. Is the umpire's decision on delinquency binding? If the umpire decides that a party is not delinquent, can I still go to the SIC?
Well, generally, the umpires do not make decisions on delinquency. They generally make decisions on whether the response to a mediation request is a cogent response or not. And if it's palpably a rubbish response, well, then we'll say it's palpably rubbish. The other party must go to the SIC court to say, umpire said this is rubbish, compel them now to give a better order, a better response, or be declared delinquent. Or the umpire might say, well, there's sufficient indication in a 3-page response from the state attorney that this is a fraudulent claim, and I've seen some of those. It clearly can't be mediated, one of those disputes. Follow Rule 7.1a now, the new one, and formulate a joint minute and go to the trial court thereafter for a date. So it's not, as the answer to the question is it's not a delinquency finding which you can take as it were on appeal. It'll be depending on the circumstances.
Thank you, Judge. The next question. Good afternoon, Judge. Please advise what happens when a defendant receives a compel order to comply within 10 days, and on the 8th day, when you try to comply, there is a special default date on the notes, although the defendant still has 2 days left in which to comply.
Well, firstly, it seems like it's a very opportunistic plaintiff practitioner who gets a default judgment date before getting the order. The instructions to judges are that they don't make the dates and they should not add dates in their orders. That is for the registrar. So there shouldn't be a default judgment date. The second instruction to judges is that 10 days has been found to be too short. That's why the amendment since 27 October prescribes in 15 days time to respond. So that gives the defendant more time to respond. And so those are the two provisions. There shouldn't be a default judgment date, and it should be 15 days. In any other instances, such as the example mentioned, I would urge the defendant then to make sure that the response is uploaded in case lines, perhaps even brought by way of a separate practice note to the attention of the judge, and or by way of a case note, widely shared case note. And in the last instance, consider appearing at the SIC court saying, here I am, we have responded, and now we want costs.
Thank you, Judge. Before I continue, I just want to note to all of our attendees that I've just turned off the chat functionality. Noting time, we have the final few questions, so you will not be able to add additional questions, but we will look to explore further sessions in the future. We do have a few more questions, Judge. We've got, I'm just checking this, 1, 2, we've got 3 more questions that we can address this evening. The first one, good evening, Judge. I was recommended as a mediator by the umpire judge, yourself, but the defendant is still non-responsive. What advice, if any, can the plaintiff's representative have as the next step?
Again, it's difficult to give case-specific responses, particularly if one doesn't have the matter before you, either to see what it's about, or which parties it is and what happened, and also where I'm not here to adjudicate a matter. But if the defendant, if there has been a nomination of a mediator and the defendant then does not participate in the mediation, it'll be the same as what I said earlier, I think to Matomi and I think to Mr. van der Vyver. The applicant will then have to approach the SIC court saying the umpire has nominated this mediator. The mediator has tried to do A, B, or C. Compel now the defendant who initially said he was going to mediate to now attend to the following, either mediation meeting or a date or etc., whatever it may be, and that can be case-specific formulated. And if he does not comply with this order, absolve me then from further participating in mediation. So on my production of non-compliance with your compelling order, court, allow me then to go to the default judgment court.
Thank you very much, Judge. Our second last question for the evening. What is the protocol in the case of 2 or more defendants where one defendant responds to the 41A and the other fails to respond?
Go ahead and mediate with the responsive one. It sounds simple, but I can give an example, and I shan't give too much details because I see there's an application for leave pending. But I had a matter the other day where the facts it need not bore you with, but the first defendant was Sanral. The second defendant was Sanral's engineer. They issued third-party notice against the RAF. The RAF issued a third-party notice against the actual contractor. All of them claiming either the split between them or contributions between them on the basis of the third-party notices. It would have been open to that plaintiff to have settled with any of them. And if it had been open to that plaintiff to have settled with any of them on either the totality or an apportionment of it, then one can do the same with mediation as well.
Thank you very much, Judge. And our final question for the evening. To what extent are mediators allowed to report on the details of the mediation session or sessions? We had a mediation that ran 2 sessions and only received a 2-liner comment. This was also a situation where opposition had been obstructive prior to and during the process, including the sessions, and the general concern raised by clients is the lack of inclusion of the obstructive conduct being included in the final report.
We've had this debate with some of the mediation organizations and mediators. Mediators are very reluctant to disclose any particulars of steps taken during a mediation process, and understandably so, due to the confidential and nature of it, and without prejudice nature of it. There is, however, a line to be drawn between someone saying, look, I want this, or I want that, or I can't live with X, Y, Z, and someone saying, I'm not going to participate. I'm sitting here because you've got a compelling order. I don't have a mandate. I refuse to even engage with a mediator, etc. So there's a line between the two. And we are of the view that the protocol and makes provision for it, that in the second half, the second part of the example, namely the what one can almost call bad faith mediation, not unsuccessful mediation with preferences, etc., but really bad faith mediation, that the mediator can and should make comment in the mediator's certificate, and we've provided for that in the annexure to the protocol. Perhaps that unsuccessful party should remind the mediator of that dividing line, and also the obligation to give an indication if there's been bad faith mediation. Bad faith mediation, of course, can attract costs at a later stage.
Thank you very much, Judge. I do note there's another hand that has been coming. I do apologize that we are out of time. You can email your questions through to info@gaa.org.za, and we will take it forward. But I do want to say a special thank you, firstly, Judge, for joining us this afternoon. We are really grateful for your time, and we appreciate the really frank discussions that we've been having with you this afternoon, and I'm sure our members can appreciate that. I also want to take a moment to again just acknowledge some of those that have joined us, to all of our members and non-members that have joined us, members from the various bar associations that are in attendance as well. We've got people from the Johannesburg, Pretoria, West Rand, and Soweto Legal Fraternity. We've got members from the LSSA and others all on the call, from the Black Lawyers Association and NADEL as well. So, and Pabasa as well. There's quite a few more, a lot to thank, but thank you very much, everyone, for joining us, and you can receive more updates. Judge, before I do, if you follow the GAA social media, Judge, before I do close, is there any final remarks that you'd like to share?
The 3 things. I thank the practitioners for participating in the manner in which they did. I take it that they're not only here to address a specific problem that they have, but really to participate in the processes to make litigation in the division work, and thereafter, as part of that, to also make mediation work. A further comment is, I hope I've brought some clarity to some of the questions which have been bothering practitioners or which may have been vexed. But having said so, remember, the remarks are general in nature and not case specific. Firstly, and secondly, I also cannot bind any of my colleagues on any of the determinations made actually in court. Other than that, you have the emails for the umpires, both in Pretoria and in Johannesburg. And we look forward to concluding the second of the first 2 terms since the Mediation Directive came into operation, and how we're going to address the challenges that flow from that, and also the benefits that flow from that in 2026.
Thank you so much, Judge, for those remarks, and once again for your time. Thank you to the Gauteng Attorneys Association, EXCO, who have put this together, particularly the outgoing EXCO member, Nicolette de Wit, who really spearheaded this, so we do appreciate that. And then from the Gauteng Attorneys Association, the Zoom link was provided by Baker McKenzie, so thank you to Baker McKenzie for sponsoring the Zoom link that enabled this. From the Gauteng Attorneys Association, I'd also like to share that if you joined in late, you want to recap, you can catch the recording, which will be made available later this week on the Gauteng Attorneys Association's YouTube channel. And thank you very much, everyone, for joining us. Have a lovely evening.